the tenure of members. What is the tenure as provided under the law? The chairperson and other person shall hold office for a term of 5 years and shall not be eligible for reappointment. So it is a one-term appointment only as provided under the Act. Both the chairman and the other two members of the permanent Lok Adalat can only be appointed for one term, which is for a period of 5 years. Chairman and other person may by writing under his hand an address to the central authority, or as the case may be, the state authority, resign his office at any time or be removed from his office. So, is once appointed as a chairperson or member of the permanent Lok Adalat, the law says that the chairperson or any of the member can at any time be removed or may resign from his office if he provides in writing to the central authority under the Act that he wishes to be removed from the office. When the chairman is unable to discharge his function due to absence, illness and other cause, the senior most in order of appointment person or permanent Lok Adalat holding the office may discharge the function of the chairman. So where there are 3 members, 1 chairman and 2 other member of Lok Adalat, and the chairman, for the reasons specified under the law, such as illness or any other cause which is valid as under the law, has remained absent from his duties for a long period of time, then in that case, the senior most member in chronological order of the permanent Lok Adalat may discharge the duties and function of the chairman of the permanent Lok Adalat. For the time being, shall discharge the function. The chairman or any other person ceasing to hold the office as such shall not hold an appointment in or be connected with the management or the administration of an organization which has been subject to the proceeding under the Act. So when a person, when the members or of the Lok Adalat or the chairman is appointed, any person who is appointed to as either in the position of chairman or as the member of Lok Adalat, in that case, he should not simultaneously be holding office with any organization that has been subject to the proceeding under the Legal Service Authorities Act of 1987. Removal of the members. So how can the member during his tenure of 5 years can be removed from the position of the chairman or as the member of permanent Lok Adalat? The central authority or the state authority, as the case may be, may at any point remove the officer, a chairman or other person who has been adjudged insolvent or has been convicted for an offense which in the opinion of the authority involves moral turpitude. Now, what is the procedure provided under the Legal Service Authorities Act for removal of the members or the chairman of the permanent Lok Adalat? The law says that first reason or ground for removal would be a person adjudged insolvent or has been convicted of any criminal offense, and which, in addition to that, it's not just adjudged insolvent or convicted of criminal offense, but also in the opinion of the authority involves that the offense should be of such nature which, according to the authority under the Act, involves any moral misconduct. Or the other ground provided for the removal of the members of the permanent Lok Adalat under the Act is when the member, which includes both the chairman and the other 2 members, have become physically or mentally incapable of acting such chairman or other person, or has acquired as acting as a chairman or the other 2 member, or has acquired financial or other interest as is likely to affect detrimental to his function as a chairperson or as other person, or has abused his position to render his continuance in office against the public interest. Now, this point, the other ground as stated under the law says that a person can also be removed from the position of chairperson or member of permanent Lok Adalat when the person has been declared or is or has become mentally incapable of acting as the chairperson or discharging his function as the member of the permanent Lok Adalat. And the other reason would be, as I just mentioned a few minutes back, that the law says that you cannot simultaneously continue to have interest in any company or organization or institution which has been subject to the proceedings of the Legal Service Authorities Act. So this in itself can also become a ground of removal of the member. So when you either have some financial interest and or you start gaining some financial interest in any company, organization, or any institution which is also subject to the proceeding of the permanent lok adalat, or has been brought within the jurisdiction of the permanent lok adalat, and therefore impact their decision or their discharge of official duty as a member or a chairman, then the member or the chairman can be removed from that position, or has abused his position to render his continuance in office against the public interest. So the act also defines what constitute public interest, and if any member or the chairman continues to abuse his position as against the and uses his powers against the public interest, then he or she may be removed from the position of the chairman or the member of permanent lok adalat. uh, Removal of members, the central authority, or as the case may be. Now, what is the procedure for removal? The central authority, or as the case may be, the state authority shall deliver or cause to be delivered to the chairperson or other person a copy of allegation and list of document and witnesses, and shall require him to submit within such time as may be allowed a written reply or statement of his defense. So, the moment any allegation has been brought against either the chairperson or the members of the permanent lok adalat, in that case, the concerned authority, as the case may be, the central authority or the state authority, may either put it in writing the allegation which has been brought against the member or the chairperson, and shall submit it within such time which will provide the the accused member to write or present a defense for himself. So where the charges has been denied by the chairperson or other person, the central authority, or as the case may be, the state authority, may appoint an officer to inquire into the truth of the allegation, as it may also appoint a presenting officer to present the case on behalf of the central authority, or as the case may be, the state authority, before the inquiry officer. So now what happens that allegation has been brought against, say, the chairperson of the permanent lok adalat, and the central authority or the state authority puts the allegation into writing, and along with the all evidence or required documents sends the allegation to the chairperson. Then in that case, and if the chairperson, after reading those allegations against him or her, believes that those allegations are false, then the chairperson or the other member, whoever the person concerned is, may appoint an officer on his behalf to inquire into the truth of the allegation, may actually send a request to the central authority to appoint an inquiry officer, and the inquiry officer shall, on the behalf of the accused member of the permanent lok adalat, conduct an inquiry and submit its report accordingly to the central authority or the state authority. After the evidence is closed by the presenting officer, the chairman or the other person, as the case may be, shall be given an opportunity to present his defense in respect of allegation, which within such time as may be allowed by the inquiry officer. So then there would be a hearing, and the accused officer would be given an opportunity to defend his case. The inquiry officer shall have power to call witness and record their statement and receive evidence on affidavits. The inquiry officer shall submit his report within a period of 6 months or within such time as by extended by the Central Authority Act and the state authority. Now, the law also provides time within which the proceeding of allegation against the member of the permanent lok adalat has to be completed. And as provided by the law, it is only within 6 months that the inquiry officer shall conduct his inquiry and submit his report to the central authority or the state authority. If the central authority, or as the case may be, the state authority, is satisfied that the charges are provided on the basis of report submitted by inquiry officer, it shall remove the delinquent chairman or other person as the case may be.